All stand. Coronial court is now in session. Please be seated.
Dr. Dwyer. Your Honour, I call Constable Zachary Rolfe. Thank you. Thank you for coming to court today, Constable Rolfe. Before you give any evidence in these proceedings, do you promise to tell the truth to the court?
Yes, I do.
Thank you. So could you please tell the court your full name?
Zachary Brian Rolfe.
You have been employed by the Northern Territory Police since 2016, is that right?
Correct.
You're still a serving police officer, is that correct?
Correct.
You're not in uniform today, is that right?
Correct.
What's your current substantive position? That is, where are you based?
I am based in the RCG house in Darwin. I've been banned from all police stations, so I believe I come under the umbrella of Serpro.
What's the just so we all understand, what's the RCG office?
It's a government building in Darwin.
You are attached to the Digital Transformations Project, is that right?
Correct.
So that is your substantive position within the police force, is that correct? Are you currently on leave?
Yes.
On the 9th of November 2019, Kumanjayi Walker passed away after he was shot by you. As a result of Kumanjayi's death, you were charged with murder and 2 alternative counts of manslaughter and engaging in a violent act causing death. In March 2022, you were found not guilty of those offences. Is that right? That
Correct.
summary? You understand that in Warlpiri and Luritja culture, it's not appropriate to speak the first name of the person who passed away for a considerable time after they have passed. Do you understand that?
Yes.
And that's why the term Kumanjayi is used? You understand that?
Yes.
Constable Rolfe, during the course of the trial, sometimes at the prompt of legal counsel, you used Kumanjayi's first name to signify a period before he passed away, and you used the term Kumanjayi after. Can I ask you to understand that it will never be appropriate in this court to use Kumanjayi's first name, so we won't ask you to do that?
Understood.
After the verdict, you resumed, well, I withdraw that. After you were charged with murder on the 13th of November 2019, you were suspended from work, is that right?
Correct.
You resumed work on the 18th of July 2022, is that correct?
Yes, I believe so.
How long have you been on leave for?
I started leave just before the Coronial started.
So the Coronial Inquest started on the 5th of September this year. You started leave just prior to that, is that right?
Correct.
How many days prior, do you recall?
I don't recall.
I want to ask you some questions first about your background. You will appreciate that the family and community of Kumanjayi Walker are interested to understand something about that.
Okay.
You grew up in Canberra, is that right?
Yes.
Where did you go to school in Canberra?
Canberra Grammar School.
You completed your schooling at that high school?
Correct.
What year did you complete your schooling?
2009.
When you were growing up in Canberra, did you have much involvement with Aboriginal people?
No, I did not.
Had you ever been to the Northern Territory at any time before coming to work here in 2016?
No.
In October 2010, you joined the Australian Defence Force as a soldier or rifleman. Is that right?
Yes.
You worked with the Australian Defence Force until May of 2015, correct?
Correct.
Why did you join the Army?
There are a number of reasons why.
What were they?
I needed a job. Didn't know anything else to do. Basically wanted to be a soldier at that time.
You were deployed to Afghanistan between July 2014 and January 2015 as part of what is known as Operation Slipper. Is that correct?
Correct.
Before you went to Afghanistan, well, I draw that, was that the first overseas deployment that you went on with the Australian Defence Force?
Yes.
Was it the only one?
Yes.
Going to a country like Afghanistan obviously involves you going to a country with a different religion, different cultural expectations. Is that right?
Yes.
Did you do any cross-cultural training or cultural awareness training before going to Afghanistan?
Yes.
Did that focus on ways to show respect for another culture and community?
I'm sure that was a part of it. I can't recall it completely.
There would be at least a part of it that would focus, wouldn't it, on how employees of the Australian Defence Force might go into a different country and behave in a way that is consistent with cultural norms, wherever possible?
I'm not sure. I can't recall it.
Do you recall any component of it that would teach soldiers of the ADF ways in which they could show respect to the culture in Afghanistan?
We were taught to be respectful where we could be, yes.
What did you gather? What did you gain from that cultural awareness program in relation to going into Afghanistan?
Again, I can't recall the training. I was taught to show respect regardless of culture.
Were you taught to show respect for culture?
Some aspects.
What aspects?
Aspects that should be respected.
Your platoon operated as a force protection unit in Afghanistan. What did that mean?
We were there to provide force protection for the mentoring elements in Afghanistan.
The mentoring elements?
Yes, the mentoring elements.
What does that mean?
The elements that were mentoring the Afghan National Army.
So did you see active service in Afghanistan? That is, were you out on patrol yourself in Afghanistan?
We were out in Afghanistan, correct.
Did you carry weapons in Afghanistan when you were out on patrol?
I'm not sure how much we're allowed to,
All right. On the 4th of May, in 2015, you transferred from the permanent service of the ADF to the active reserve. Is that right? What did that mean?
That was a way to transition out of full-time to part-time and start my separation from the military.
So can I ask you to keep your voice up because you're not being captured on the recording?
Yes.
Could you repeat that answer, please?
That was a way for me to transition from full-time to part-time and start my separation from the military.
What were your reasons for leaving the military at that time?
I wanted to move on.
Why?
I felt like moving on.
From December 2015 to February 2016, you submitted several applications to join Australian police forces around the country. Is that right?
Correct.
On the 22nd of April 2016, you received an offer of employment from the Northern Territory Police Force. Is that right?
Yeah, if that's the date, that's the date. I'm not sure of the date.
You recall it was 2016, wasn't it?
Correct.
And you went through a recruitment process to be engaged to be a police officer in the Northern Territory?
Yes.
On the 30th of May 2016, you commenced recruit training in Darwin. Does that accord with your memory?
Yes.
You were in squad 129, is that correct?
Correct.
On the 30th of June 2016, if you can take it from me, you are recorded as completing an element of training called Respect, Equity and Diversity online training. Do you recall anything about that?
Yeah, I recall that. That we were trained in that way.
What did that involve? Respect, equity and diversity?
Pretty self-explanatory. It was teaching us about elements of respect, equity, and diversity in the workplace and in the public, I believe.
Your training records suggest that was online. Do you remember that? You filled out forms on a computer in relation to that?
Yeah, I remember a lot of online training we did.
Do you remember any face-to-face training that you did on cultural awareness or cultural competency?
I believe we did have a small block of that.
What did that involve?
As far as I can recall, I thought we just had a small, could have been part of the day with an instructor talking about the culture in the NT, I believe.
Do you recall the name of the instructor?
No.
Do you recall whether or not the instructor was an Aboriginal person?
No, I can't recall.
Do you recall whether you left Darwin for the purposes of that instruction?
I don't think I left Darwin for any instruction.
Do you recall whether the cultural competency course was delivered in a classroom or on country?
I believe all of my training was in the classroom, except for one day where we went to a community in Darwin. Like a town camp, sorry.
Was it Bagot Community that you went to?
I believe so.
Do you recall speaking to any of the elders at Bagot Community?
During that day?
Yes.
Yeah, I believe we spent the day speaking to the elders and the community members.
You mentioned earlier that you learnt about cultural awareness within the Northern Territory. Did that distinguish any different cultural groups in the Northern Territory?
I believe there's multiple differences in the cultural intricacies through each community.
There's a multicultural community, there's a Greek community, there's Asian communities living in Darwin, there's Aboriginal communities. Did you learn about that in the cultural context? That
I believe our training focused on the Indigenous communities.
Was there anything of value to you in that training?
Yes.
Can you tell us anything that you took from it?
Well, it's taught me about Indigenous culture that I wasn't aware of, aspects of it.
Like what?
Look, there's lots.
Anything specific to your work that you can recall?
To be honest, the cultural training that we did, I haven't found the specific use of that in the job, because I'm just responding to human problems of humans asking for help and then humans breaking the law. I have not been presented with a problem, a cultural problem as a police officer. In saying that, I was in Alice Springs.
Did you receive any training in relation to cultural competency or cultural awareness that related to anything you might have dealt with as a police officer in Alice Springs?
Well, I believe we may have in that training, but again, I haven't come up with so much of a cultural clash as a police officer. I've come up with a behavioural clash amongst humans.
All right. I'm going to ask you to keep your voice up again, Constable Rolfe, if you don't mind.
Yeah, copy.
In relation to a clash between humans, I appreciate you're trying to make a point about something. What is it? Do you want to explore that? Do you want to expand on that?
No, I'm just saying that, like, as a police officer, I'm responding to a job where someone has called for help or someone has broken the law. I have not been called to a cultural issue.
Aren't you often, as a police officer, actually engaging in general duties work where you might, for example, travel in a police car on the streets of Alice Springs and see whether or not there is anybody needing assistance?
Yes.
Do you say that you received no training in terms of cultural awareness that assisted you in that job?
No, I'm saying we received cultural training, but look, again, I haven't responded to cultural clashes in the job.
Is there any part of your training within the Northern Territory Police Force to be taught about the history of colonisation in this country?
Yeah, I believe we had a minor part of that.
Did you learn about any of the, for example, historic massacres that Aboriginal people experienced?
Yeah, I believe. I believe we have, yes.
What particular massacre did you learn about, or multiple? Tell us.
Or the massacre that we've been talking about in this Coronial, like the Coniston massacre, we talked about that.
That you learnt about that in your training in Darwin, did you?
I believe so.
Did you learn about the dispossession of Aboriginal people from their country as part of your training as a police officer?
Perhaps.
Did you learn about the stolen generation and the impact of that for people in the Northern Territory?
Yes.
Did you have any training in the trauma that Aboriginal people have experienced as a result of what we just talked about, the dispossession and the massacres that they've experienced?
I'm not sure if we had training on that.
Was that something that you understood? That is, had you read about that, or did you have any understanding of traumas of Aboriginal people prior to your work in Alice Springs?
Traumas of some, yes.
What can you tell us about that? What was your understanding of trauma that Aboriginal people had experienced as a result of colonisation of this country?
Well, I wouldn't paint a whole group of people with the same brush and say that everyone's traumatised by the same thing. I'd say that some people that we've learnt about have been traumatised intergenerationally from what's happened previously.
Is that something that you learnt about during your training as a police officer?
I can't recall if that was in police.
On the 8th of I'll withdraw that. Just before I move on from some of the training you received in Darwin, did any of that training involve ways in which you as a police officer could show respect to Aboriginal people?
I believe we were taught to respect everyone.
So are you saying in that answer that you were not taught any particular ways in which you might show respect to Aboriginal people?
Well, I think it's the same in the way that you would respect anyone else.
So the answer to my question is no, is it? That you did not receive any training in relation to how you might show show respect to Aboriginal people anywhere in the Northern Territory?
No, because if we were taught how to respect everyone, Aboriginal people are included in that.
Okay. So say if you're talking to me in a community, same if you're talking to me as to anybody in, for example, Yundamu or Willara or Uluru, it's exactly the same, is it, in terms of your training?
No, we were taught to treat people in a way that they understood and a way that they would feel comfortable according to that individual.
How would you do that? What were you taught about that?
We would have to establish how that individual would feel comfortable. If someone would, for example, if you spoke to a fellow lawyer, he could understand what you're saying, but if you're speaking to a tradie or me, I might not understand all the same words that you guys understand, so you're going to have to dumb it down for me, for example.
So what would you do when you were speaking to an Aboriginal person? Would you dumb it down?
I would speak to them how they felt comfortable.
How? How would you do that? What did your training allow you to... how did your training teach you to adapt when you were speaking to an Aboriginal person?
The same way you would adapt by speaking to anyone else. You speak to them, establish how they would feel comfortable in your communicating way and do that.
When you left the academy in Darwin, you had a choice, did you, as a young recruit, of working in Katherine or Tennant Creek or Alice Springs, is that right?
Yeah, I believe you could put your priority in.
What was your priority?
Alice Springs.
Why was that?
From what I'd heard, it was the busiest station. I was able to get the most experience in the quickest format.
Why was that of interest to you?
Because I wanted to improve. I wanted to learn my career as fast as possible, or learn my job.
Were you enthusiastic about your role in Alice Springs? That is, when you started in Alice Springs, did you go into the police force with a sense of enthusiasm about the job?
Yes.
Did you receive any sort of induction when you started in Alice Springs about the different community groups that you would come into contact with in policing?
Yes.
How did that happen?
I believe we had a day or two in the station before we actually started work as a group of the new recruits that went down there.
And did somebody deliver that induction package?
Yes.
Who was that?
Can't recall.
Was it an Aboriginal person?
Can't recall.
What can you tell Her Honour that you learned about the different communities that you would be engaging with in and around Alice Springs?
Well, we just got taught about the different town camps in Alice Springs and the communities surrounding it. More so geographical, was more geographical training versus different cultural idiosyncrasies between the communities.
So there was nothing particular about ways in which you would show respect to Aboriginal people in and around Alice Springs?
Not that I can recall specifically.
You have given evidence, I think, to the effect that in terms of speaking with Aboriginal people or working alongside Aboriginal people, you would treat them exactly the same way as you would a non-Aboriginal person. Is that right?
Well, yeah, generally, I'd treat everyone the same.
You would show respect for an Aboriginal person in the same way you would show respect for a non-Aboriginal person. Is that your evidence?
Yeah, I believe that's what you should do.
I'm going to ask that you be shown MFIC. Could you turn to page 3, please? There's an exchange between you and Officer Mark Sykes. He's another police officer, correct?
Correct.
He was someone you served in Afghanistan with, is that right?
Correct.
So he's previously been in the army and then moved to the police force too, correct?
Correct.
The exchange involves this. Constable Sykes texting, have you heard you had a rough arvo yesterday, grubby fucks? It's the 27th of April 2019. You reply, nah brah, just slightly annoying, haha, coons man. Do you agree, Constable Rolfe, that the content of that message is obviously racist?
I wish to exercise my right and claim the penalty privilege on the basis my answers might tend to expose me to a penalty.
There are a number of other messages on your mobile phone that was in your possession in 2019 that I want to ask you about. With respect to other material on that phone that is racist, is your answer the same?
Correct, I'll claim the penalty privilege.
With respect to messages on your phone that relate to the use or misuse of body-worn video, is your answer the same?
Yes.
With respect to messages on your phone that relate to the use of force, is your answer the same?
Yes.
Your Honour, I intend to show Constable Rolfe a video of a particular incident in Alice Springs and ask him a question.
Yes.
Constable Rolfe, that footage is found on your phone with a date of the 10th of April 2019. It appears to be film of CCTV footage. Is that correct?
That's what it appears, yes.
Do you recognise the two officers who are standing at the tables?
I believe I know one of them.
Is that an area around Epilogue, a bar that exists in Alice Springs?
I believe so.
What's the name of... Sorry, I withdraw that. Are you one of those two officers?
No.
What's the name of one of the officers you know?
I believe it's Don Cockatoo Collins.
I'm sorry, could you repeat that?
Don Cockatoo Collins.
Your Honour, I asked for a non-publication order, temporary one at least, over the name of that police officer until we've had an opportunity to speak with him about that incident.
Yes, I now grant a non-publication order or make a non-publication order over the name of that officer.
Do you know the other officer who was standing there?
No, I can't recall. I probably did at the time.
Why is that incident on your mobile phone?
I wish to exercise my right and claim the penalty privilege on the basis my answers might tend to expose me to a penalty.
I'm going to show you a table of objections to topics or categories of questions, which I understand has been prepared with the assistance of your legal counsel. There are 1 to 14 topics or categories of questions listed here. And I'll just provide a copy of that table to my learned friends as well.
Yes.
I won't read all of those incidents onto the record, Constable Rolfe, but you'll see there that the first category of objections relates to text messages that are arguably racist, sexist or homophobic, or as they relate to the use of force incidents and the events of the 9th of November 2019. You've claimed the privilege with respect to those categories of questions, correct?
Correct.
And is the list of 1 to 14 there an accurate representation of the topics or categories of questions that you would claim an objection in relation to?
Yes.
You want to attend to that list?
Yes, that will be the next exhibit in these proceedings.
Exhibit 22.
Thank you.
Just to make that, or to try to make sense of that for those listening to these proceedings, there are a number of categories related to text messages. There are a number of categories related to use of force incidents, and there is a final category relating to the events of the 9th of November 2019. Constable Rolfe, do I understand that if I was asking you questions about the events on the 9th of November 2019 leading up to Kumanjayi's death and involving Kumanjayi's death, you would take that same objection at this point?
Yes.
Your Honour, might I now invite Dr. Freckleton to help clarify one issue, and that is that my understanding is that with respect to a number of these incidents, disciplinary proceedings have begun. In respect to some of them, they may have finalised. If Your Honour was going through the process required by Section 38 of determining first whether the privilege applies, and if it does, whether or not a certificate would be granted, Your Honour would want to be informed about the stage of those disciplinary proceedings. I don't invite Your Honour to have to go through that process now, but I do ask that Dr. Freckleton put on the record clearly what is the situation with those matters.
Sorry, just before Dr. Freckleton does, I've informed Council Assisting I'll be making some brief submissions after Dr. Freckleton.
Yes.
Indeed, I will be inviting you to go through the process you've got involved in for the purpose of each of these objections, but I don't envisage those submissions being overly long for the purpose of today.
Yes. Dr. Freckleton?
Thank you, Aaron. Your Honour, I'll go through 14 categories. They may not correlate with the order of the document that's just been distributed. I apologise for that.
Would you like the left turn?
That would be helpful, thank you.
There's another one.
Thank you. I'll start, Your Honour, with the matter involving Chris Walker. I will refer to people's names, save a minor to whom I will make reference without referring to his name.
Yes.
The first matter is that involving a Chris Walker, which involved an entry into a house with a gun drawn.
So we're talking about item number 11
That's number
on
11.
exhibit 22.
Yes.
Yes.
That related to a person who made a complaint to police and said that they were hiding in a bathroom. And Your Honour will recall that resulted in an arrival at the house of the person by a number of officers, including Constable Rolfe. No disciplinary action ultimately has been taken in respect of that matter on the basis of a view that the basis for the entry was justified and the use of force was not excessive. That matter therefore has been finalised. I move now to the one which is relating to two intoxicated males at Araluen Park, which is number 6 on Your Honour's list.
Yes.
That matter too has been finalised. It has resulted in a decision to provide remedial advice to Constable Rolfe. That will be provided to him as part of his OSTT requalification training. That has not been able to be provided to Mr. Rolfe to this point because he has been absent for work on the basis of serial medical certificates, the first extending from the 10th of August to the 4th of September, the next from the 9th of September to the 9th of October, the third commencing on the 10th of October, and its expiration is the 9th of December.
Your Honour, may we have the dates that these things were finalised so we know when that occurred, as well as what dates are pending in terms of what might be further done? For example, for the first one, when was the use of force issue concerning Walker finalised, etc.?
Do you have that
I
information?
don't have that at hand, Your Honour, but there are two affidavits from Assistant Commissioner Porter which refer to most of these matters, and I can liaise with one of the friend in due course.
Thank you.
One of the issues which arises in respect of these matters is a statutory one, Your Honour, namely Section 162, subsection 6 of the Police Administration Act of the Territory. And that provides that an action under Part 4 in relation to a breach of discipline must be commenced within 6 months after the act or omission constituting the alleged breach of discipline was discovered. Your Honour will hear evidence about this from Assistant Commissioner Porter in due course. But the options available for addressing the conduct of Constable Rolfe were limited by reason of a decision that was made by the Northern Territory Police Force to avoid any possibility of interfering with the fair trial of Constable Rolfe by requiring of him explanations and engaging in disciplinary actions against him while the criminal action for murder was current. So in respect of this matter, for instance, the only option in the circumstances was remedial advice given when the matter was investigated and when it was finalised, to take up the issue raised by which is number 6. The third matter, Your Honour, is the Todd Tavern incident, which is number 9 on your list. This was a matter where a man was questioned, who then ran away. He was chased for a distance in the order of 300 to 400 metres, and he collided with the outside part of the tavern, an artificial impediment that existed outside the tavern. He was taken to hospital for shortness of breath and chest pain and the effects of having collided with that impediment. This was another of the matters that came into this category of being investigated after the expiration of the Section 1626 permitted period. The decision has been made to provide Constable Rolfe with remedial advice. It's not been possible because of his taking of leave on the occasions described already to Your Honour. The next matter is number 10 on your list. So this is the fourth of the matters to which I'm making reference. This is the Albert Bailey matter, Your Honour, where it appears from the video footage that a man and a woman were having an argument. Members of the Northern Territory Police Force ran across the lawn and the victim was pushed at full speed, it appears, by Constable Rolfe into a wall of the building. He struck his head on that wall, and that required suturing. Your Honour heard evidence about that from Mr. Hanson previously. Mr. Hanson was given remedial advice in respect of it. A Section 79 notice was served upon Constable Rolfe. He responded, and that was on the, I think on the 31st of October. Constable Rolfe responded that he did not admit having used excessive force.
Is that this year?
A notice of investigation under Section 81, subsection 3, paragraph B, was then served upon him, and the disciplinary matters in respect of that issue are ongoing. What can take place hereafter is a decision that there was no breach of discipline, or there was a breach of discipline. If it is found that there was a breach of discipline, a variety of consequences can follow, including his being charged in a disciplinary sense. Those are matters to be resolved in due course. The next matter is number 7 on your Honour's list. It relates to Cleveland Walker. Cleveland Walker, as your Honour will recall, was arrested after a foot chase, and he sustained injury to his head and his nose. Constable Rolfe's body-worn video had been turned off prior to the apprehension. A number of persons were involved in that matter, including Sergeant Kirkby, Constable Rolfe. Remedial advice was provided to Constable Rolfe on the 26th of July of this year. I move then to the matter of Malcolm Ryder, which is number 8 in your Honour's list.
So number 7's finalised.
I'll come to.
You told us that the remedial advice has been provided.
Yes, that's right. I beg your pardon, right. Yes,
and it
that's
has
right.
been finalised.
Yes, that's so. So I'm moving then to the Malcolm Ryder matter. Number 8 in your Honour's list. Your Honour will recall that this is the matter where Judge Borchers found evidence by Constable Rolfe that he said could not be relied upon, and that Constable Rolfe had not been truthful in his evidence. This evidence has been scrutinised by Professional Standards Command, and a decision has been made that the matter is concluded in respect of the honesty issue, if I can term it that way, and the perjury charge will not be preferred against Constable Rolfe, in spite of the troubling issues raised by Judge Borchers. I move now to.
Can I add the word finalised to those
Yes, you can, Your
comments?
Honour. That one's finalised.
And could my learned friend clarify that that's a criminal charge of perjury, that won't be preferred, but with respect to any disciplinary proceedings following from Malcolm Ryder, have they been finalised or are they not preferred?
Those are finalised.
So what was the actual distinct sentence that survives us?
The explanation of what has taken place in that regard is to be found in the second affidavit of Assistant Commissioner Porter. at page 16, the outcome is explained there.
Do we have it? Can you do that?
I move now to the matter involving the minor, which is the 14-year-old boy in a bin. That is number 5 in your honour's list. This again falls into the category of matters that are outside the 162 subsection 6 situation. This matter is currently in the hands of Professional Standards Command that are further considering the matter, but by reason of the timing of the issue, the only potential outcome in that regard is the requirement of the provision of remedial advice. And if that is the outcome, which will be determined imminently, it would be provided at the same time as the other forms of remedial advice at the post requalification, if and when Constable Rob returns to work.
What does OSTT stand for?
Operational Safety Tactical Training. Right? I always forget to what one of the T's. Yes. It's seemed to professional standards that would be a suitable occasion on which to speak with Constable Rolfe about his approach to apprehending persons and the methods that he should employ to minimise risk and harm to any person whom he is called upon to intervene with. So I've referred to the minor. I move now to a matter involving Luke Madrill, which is number 12 in your honours list. This is a matter in which excessive use of force was alleged during an arrest, as well as rudeness by Constable Rolfe. And what was asserted by the complainant was that he sustained an injury to his knee at the time of an arrest, and it involved a hill. Again, remedial advice was provided in relation to the usage of body-worn camera. That was given to him on the 27th of July of this year.
Is that finalised
Finalised, therefore, Your Honour.
in both aspects of body-worn video and any use of force?
Yes. I move now to the matters at Uendamu. They're number 14 in your honours list. Remedial advice was provided to Mr. Hawkins in respect of his role in the matters at Uendamu on the 27th of July of this year. Remedial advice is pending to Sergeant Frost and Constables Ebel and Rolfe. Mr. Kirstenfeld is still to be interviewed in respect of that matter, so it is not finalised in relation to him. So that matter is ongoing. I move now to number 4 in your honours list.
Just on 14, but for the provision of remedial advice, the investigation is otherwise finalised?
Yes. That's insofar as it concerns Mr. Rolfe.
Yes.
I move now to number 4, Your Honour, which is his failure to disclose matters in relation to his service in the ADF.
You might have mentioned number 13. There's one use of force incident which I haven't made a note next to, but I might have missed.
No, I haven't mentioned it. Coming to it next, if I may, Your Honour.
Sure.
So 14, the one after that one, is the ADF record matter.
Yeah.
I beg your pardon, number 4. Beg your pardon. Thank you.
Is it limited to the ADF information?
Yes. At the time of the application, of course, it being a recruitment issue, Constable Rolfe was not a member of the police force. So there were statutory limitations in terms of charges that could be preferred. The decision has been made not to pursue that matter further, and so Your Honour can regard it as finalised in terms of either criminal or disciplinary action. I move then to number 13, the one to which Your Honour made reference,
Sorry.
Antonio Woods. This was an allegation that Mr. Woods was tripped and fell and hit his head, and lying face down on the ground. It involved Constable Rolfe, Constable Kirstenfeld, Constable Hanson, Sergeant Kirkby. Remedial advice was provided in relation to body-worn footage issue to Constable Rolfe on the 26th of July of this year. And for completeness sake, remedial advice was provided to Constable Hanson, Sergeant Kirkby in relation to body-worn footage camera issues on the 16th of August and the 24th of August respectively. And remedial advice for rudeness was provided to Constable Kirstenfeld on the 20th of July.
Is that matter finalised?
That is finalised, Your Honour.
Body-worn and use of force
Yes, it
issues?
is. It is. I move then to number 2 in Your Honour's list. And that relates to a variety of matters, including the sending of body-worn video footage to persons not entitled to be privy to it, drug use matters, discriminatory remarks, and I think Your Honour has this in numbers 2 and 3 separated. So it's the right, I beg your pardon. So number 2 is the text messages relating to the recording and dissemination of body-worn video. So I'll refer to that first, and then I'll refer to the other matters, which are 1 and 3 together. The outcome is the same. The situation in that regard is that action has been taken in relation to Constable Rolfe And the hearing officer involved is a senior member of the Northern Territory Police Force, handed down his decision in relation to various legal challenges that were made to the usage of material downloaded from the telephone of Constable Rolfe, taken into possession of the Northern Territory Police Force at the time of the arrest of Constable Rolfe for murder and other charges. So that decision in respect of legal matters was handed down on the 12th of October. It is open to Constable Rolfe, if he is so inclined, to seek judicial review of the correctness or otherwise of that decision as a matter of law by the 12th of December of this year, Your Honour, to enable Constable Rolfe to make a decision in that regard. The hearing is adjourned.
Sorry, which hearing?
The hearing in respect of the body-worn footage sent to persons not entitled to receive it. And I'll refer to the associated matters presently. The hearing is listed to resume on the 13th and 14th of December of this year. There are two phases at that stage, Your Honour. The first is, if you like, the finding as to whether there has been a breach of discipline, and then if that is found, then penalties can be imposed. In Your Honour's list, there are two other matters, numbers 1 and 3. The first relates to the content of text messages about which you've heard much evidence that are said to be racist, sexist, homophobic, disrespectful and inappropriate in a variety of ways. All of that material falls into the same category as that to which I've just made reference. In other words, the legal issues are the same, and the hearing has been listed to resume on 13 and 14 December as required. The next matter is number 3 in Your Honour's list, which relates to text messages relating to the usage of drugs, either illicit or prescribed by Constable Rolfe. And again, the status of those matters is the same. So in short, in respect of those 3 categories of matters, 1, 2 and 3 in Your Honour's list, disciplinary action is partially completed, and the hearing will resume on 13 December unless once more action is taken by Constable Rolfe to assert some irregularity or impropriety or illegality in the process by way of an application for judicial review in the Supreme Court. There is another matter which is not on Your Honour's list, and that relates to conduct of Constable Rolfe in being interviewed by the Spotlight program and associated matters. That matter is finalised, and a formal caution in writing was issued to Constable Rolfe, and he was ordered to be of good behaviour for 12 months. So to summarise, Your Honour, of the matters on Your Honour's list, plus the additional one to which I've just made reference, all are finalised, save the trio of matters related to the telephone and the matter involving Mr. Bailey.
It doesn't mention possible.
Your Honour is aware that there is an application for judicial review on behalf of Mr. Rolfe, which is currently before the Supreme Court and will be heard presently. That extends to the protection which Your Honour has purported to provide, and I don't say that with any criticism, to Constable Rolfe in respect of not just criminal charges but also disciplinary charges. So therefore the construction of Section 38 of the Coroner's Act. Upon those matters being resolved by the Supreme Court, which I think we're all hoping will be imminent, the status of what is taking place in these ongoing matters can be further considered by Your Honour and be the subject of further submissions. So that refers to those four categories amongst those already described.
Yes.
Hope that assists Your Honour and Counsel assisting.
Thank you. Mr. Mullins?
Your Honour, just for the benefit of the family and other members of the community, can we have a brief explanation from Mr. Freckleton as to what is remedial advice?
I'm happy to do that. It consists of an assertive conversation by a senior police officer with a member to provide guidance and mentoring to them in respect of the way in which they conduct themselves. It's not a formal disciplinary outcome, but it's intended to provide assistance to them. So if something has been identified which is inappropriate in the way that they have conducted themselves, they can be guided to do better. Your Honour will see that an example of remedial advice is annexed to the affidavit of Mr. Porter, the second one of those. That's an example of that. Sometimes it's in writing. It's usually accompanied by a meeting in which the officer is spoken to by a much more senior member, and that guidance is imparted, and there can be interaction. And the notion lying behind it is that the member can learn and improve their conduct in the future. And it also constitutes a basis for further action if the member does not learn and repeats the kind of conduct involved.
Mr. Bowe?
Your Honour, just two matters. It may assist Your Honour in addressing the Section 38 issue if it was disclosed whether in any of those incidents the constable gave a version in response to the issue being raised of him, and whether that version was under Section 79A or not. I don't know. That information is not in the Porter affidavits. It may bear on the question as to whether or not the certificate covers any concerns, and that's a matter about which I was going to make some further submissions about at some stage.
We'll need to follow up on that to assist our learned friend. The effect, of course, of the Section 38 certificate, assuming that Your Honour's certificate is valid on its face, in other words, that it extends to both criminal and disciplinary matters, is that whatever is said by the member cannot be used against them in future criminal or disciplinary proceedings. That's all. It's not an indemnity. It's simply a preclusion on the use of the words uttered in the witness box against the member.
We appreciate that. It's really whether or not there's any increased risk to the member in giving evidence in this court in relation to any outstanding matter.
As to whether or not a version has already been given.
Correct.
I don't know if that increases the risk, Mr. Bowe, but
No, I'm not saying it does. It may be a question that's relevant to Your Honour and perhaps relevant before the Supreme Court, whether the claim to refuse to answer goes to increasing any risks, if there are any risks still existing in relation to these matters.
well, Dr. Freckleton, are you able to advise us now or later, and we can take that further if need be?
In respect of the other Bailey matter, I cannot advise Your Honour at this stage, but we will ascertain the position. The only other set of matters is the trio, and no formal statement to our knowledge has been made by Constable Rolfe in respect of those matters.
Just before you call on Mr. Officer, can I clarify two issues? The first is in relation to Mr. Bailey. At page 14 of the affidavit of Deputy Commissioner Porter, there is information with respect to the outcome of the Bailey matter. Remedial advice was provided on the 4th of October 2018 to all members who failed to activate their body-worn video footage, and that included Constable Rolfe. So that was the 4th of October 2018. I apologise, it's Assistant Commissioner Porter. And the table attached to the Assistant Commissioner's statement indicates that there was consideration of a perjury charge, but one will not be laid. In relation to the remedial advice provided for failing to activate the body-worn camera, that was delivered, and it was noted that there was insufficient evidence to sustain an allegation of excessive use of force, perhaps because of... Well, I just asked my learned friend to clarify. It's page 14 of the affidavit of Assistant Commissioner Porter.
Which affidavit? I think there is.
It's the second affidavit. 2-111C, 2 September of this year.
Excuse me, Your Honour,
I don't just have a word.
Sure.
I'm sorry, Your Honour, I said the word Bailey. I'm intending to refer to Malcolm Ryder and the complaints made with respect to Malcolm Ryder. I think my learned friend earlier referred to a particular page in Assistant Commissioner Porter's affidavit. It is in fact clarified in the table at page 14 that remedial advice was provided to all members for failing to activate their body-worn camera. That remedial advice was certainly provided to Constable Rolfe because he was one of the officers who failed to activate his body-worn camera. And that table notes that that remedial advice was provided on the 4th of October 2018. With respect to the allegations of excessive use of force, you recall Malcolm Ryder was a gentleman who had sutures in his head, 13 sutures in his head. There was insufficient evidence to sustain the allegation of excessive use of force. And I note the absence of body-worn video footage in that matter.
My learned friend is correct in that regard. We've got the individual sorted out now. In what I said to Your Honour, we only referred to the further matter, which is the perjury matter, that not the decision being made not to proceed against him for that. But what our learned friend has said, referring to page 14 of the second Porter affidavit, is correct, and that means that that aspect of the matter is finalised as well.
Yes. So as I understand it, the only matters that are not finalised so far as disciplinary proceedings are concerned are matters 1, 2, 3 and 10 on Exhibit 22.
That's my understanding, Your Honour, and that's consistent, I believe, with what Dr. Freckleton has outlined. Can I just clarify one issue, and that is in relation to number 4, and Your Honour asked a question of Dr. Freckleton. Number 4 reads, suggested false information in relation to the application to the Northern Territory Police Force. Your Honour wanted to clarify whether that was only in relation to a suggestion of false information about disciplinary proceedings. As I understand it, that covers any suggestion of false information. So, for example, related to a previous charge in Queensland and related to previous applications to other police forces in the Northern Territory. But I understand that the answer from Dr. Freckleton is the same, which is because Constable Rolfe was not then a member of the Northern Territory Police Force, there are statutory limitations on what disciplinary proceedings can follow. Yes, thank you.
And I should qualify what has been said in relation to the events of 9 November. I've informed Your Honour about the remedial advice pending for the 3 members. There are some associated matters which are still ongoing in relation to the matters of 9 November, and it would be inappropriate for me to go into details in respect to those at this stage, Your Honour. However, Your Honour will note that the period of time limitation applies in respect of such matters, so there are major limitations in terms of anything that can be done in respect of the 9 November matters. And this highlights an issue that we will raise with you in due course in our submissions about the legislative constraints which inhibit the capacity of the Northern Territory Police Force to deal with persons in a disciplinary sense in many contexts.
Yes.
I might be about 45 minutes, if you want me to start now and proceed, I can. Your Honour, the first point I just want to deal with is the claim for a privilege, in other words, the categorisation of penalty privilege, and I don't seek to recanvass what Your Honour said in your ruling, that is ruling number 5, but what I do wish to make clear is the extent and nature of the privilege as background, why these claims have been taken, and then take you on through why it is that Section 38 applies here and why you should approach your decision in relation to on each of the topics for the purposes of today. But equally, as Your Honour is aware, the matter will be before the Supreme Court, in which Constable Rolfe has applied to be joined as a plaintiff, where the issue about the nature and extent of the privilege should be determined, whether it's consistent with Your Honour's ruling or otherwise. And coupled with that, it will certainly have a consequence for how the privilege might or might not be taken before Your Honour as the inquest proceeds. Can I just start, Your Honour, by referring, and again I'm simply referring to labour foundations for why the privilege is taken, why it's go behind Your Honour's ruling. Now, labour foundation for when a privilege claim is taken for exposure to a penalty, which comes from a decision, a reliant decision of Australian Property Holdings Limited versus Michael Woolridge, which was a decision in equity. However, my respectful submission is it applies here in terms of the test upon which I can give that citation. That is 2012 BSC 576. The basis upon which a privilege claim for exposure to penalty can be taken, and it starts at paragraph 80, where it is said by Justice Robson, a common law privilege against exposure to penalty is based on the deep-seated belief that those who allege the commission of a crime should prove it themselves and should not be able to compel the accused to provide proof against himself. At 81, common law privilege against exposure to penalty may be successfully invoked in both penalty proceedings and other proceedings where a penalty is not sought but may otherwise expose a party to penalty in other proceedings that are on foot or anticipated. So the point I make about that, Your Honour, is Constable Rolfe doesn't need to demonstrate that there is in fact actual proceedings, although in this case we know there are some, nor does he need to demonstrate that proceedings are likely, it is actually, or otherwise, potential exposure to disciplinary proceedings, which could amount to a penalty. And Your Honour, that decision is important in the context of the legislative scheme in which discipline is administered with the police force in the Northern Territory. And Your Honour, if you can, or if not, pull up the Police Administration Act.
Sorry, I didn't get to.
1978, I should have given you advance notion on, but it is important that I take you through the scheme.
Do you have a hard copy for me?
Right.
One, Your Honour.
Police Administration Act, section.
Part 4, starting section 76.
Thank you.
And Your Honour will see there Part 4, discipline, and the header, duties and obligations of members, and it lists breaches of discipline. And it's important, Your Honour, that I note the following in which the potential exposure exists for my client.
Just give me one moment.
Yes, Your Honour.
Yes.
Your Honour will see section 76A that a member commits a breach of discipline if they engage in disgraceful or improper conduct, either on or off duty, or B is negligent, inefficient or careless in the discharge of the member's duties, or C contravenes or fails to comply with the provision of a code of conduct referred to in section 14A, Capital 2, and that's the provision dealing with the Commissioner being able to promulgate general orders. D, fails to obey a lawful direction, instruction or order given by or cause to be issued by the Commissioner or a member having authority over the member, including general orders and instructions issued under section 14A, and directions, instructions or orders given in relation to a breach of discipline or an alleged breach of discipline. Or D, B, fails to be of good behaviour for a period fixed under section 84DC. That will be relevant as I advance these submissions a bit later. Or H, aids, abets, counsels or procures, or by any act or omission is directly or indirectly knowingly concerned in or a party to a breach of discipline committed by another member in circumstances referred to in the aforementioned paragraphs. As Your Honour turns the page, Your Honour pulls up section 78, and that talks about public interest dismissal, which says that notwithstanding anything else in the Act, the member may be immediately dismissed from the police force where the Commissioner, A, is of the opinion that the member has committed a breach of discipline, and it is in the public interest that the member be immediately dismissed, and B, has taken into account any written response of the member made after service on the member of a notice under section 79. Your Honour, section 79, capital A, deals with disciplinary powers generally, and it's a matter to which I will return to assist the court in terms of what was raised by Mr. Bowe. I will do that a bit later. If Your Honour pulls up section 79, that is the service of a notice for alleged breach of discipline. And Your Honour, where the Commissioner believes on reasonable grounds that a member, or prescribed member believes on reasonable grounds that a member of a rank below the prescribed member, a prescribed member is anyone from senior sergeant and above, has committed a breach of discipline and considers that the breach is serious enough to warrant action being taken under this part, the Commissioner or prescribed member shall serve a notice under section 84F on the member. And Your Honour, I won't go through every provision thereafter, but once a response is put in, the response could be accepted and no further action is taken, or an investigation can be commenced with section 81. Consequences of which, again, no further action might be taken, or counselling portion of the member or causing the member to in writing, or ultimately can be charged with a breach of discipline. Your Honour, section 84, capital D, is the order of the Commissioner or prescribed member, and this deals with the penalty upon a consequence in which a finding of a breach of discipline has been substantiated or proven. And Your Honour, they range in severity from as low as counsel and cautioning, including the imposition of good behaviour bond for a period of 12 months or less, a fine, reduction in rank, reduction in salary, transfer of a member, a suspension, an order of costs by way of compensation, or ultimately the most serious in terms of the police officer dismissal from the police force. Your Honour, if I can for a moment hand to you the Code of Ethics. I have a copy for the parties. I have a few copies, not for every single one.
Does it become an exhibit at this stage, the Code of Ethics? I know we've referred to it.
I couldn't find it.
We'll just check on that, Your Honour.
Now, Your Honour will recall,
If it isn't yet an exhibit,
I'll check that, Your Honour, yes.
thank you.
Your Honour will recall when I was taking you through what amounts to a breach of discipline, it can be a contravention of the Code of Ethics. And Your Honour, it is important I take you through some of that to emphasise the submission I made in respect of the claims taken by Constable Walker. Turn to page 3, and it sets out the purpose of clause 2. The purpose of this general order is to provide instruction, guidance and advice and make explicit certain behaviours that are unacceptable for all, regardless of rank, and to provide an ethical framework for members' decisions and actions. At clause 4, under coverage, this general order and Code of Conduct and Ethics applies to all members of the Northern Territory Police Force. Clause 5, throughout this general order, some paragraphs are bold and italicised. Those paragraphs are intended to be prescriptive in nature, and if a member breaches any one of them, they may be subject to the disciplinary provisions of the Police Administration Act, which I've taken you on through. Some of those bold, at least on my copy, aren't italicised, bold clauses start at page 5. Your Honour will note under personal conduct, clause 19, members must act honestly and integrity at all times. Clause 20, members must always conduct themselves both on and off duty in a proper manner that does not bring or has the potential to bring discredit to or adversely affect the police force. 22, in the exercise of their power, members must be honest, impartial and consistent and never act arbitrarily or with malice. 26, members should always conduct themselves in a professional manner that is lawful and in the spirit and intent of the Code of Conduct and Ethics. 27, members must be receptive and responsive to lawful orders and instructions given by the Commissioner of Police or any person legally entitled to give such order or instruction. Members must carry out their lawful orders or instructions promptly and to the best of their ability. 28, members may only use force that is lawful and reasonable in the circumstances. Clause 29, members must always perform their duties promptly with due diligence and to a satisfactory standard. I skip forward, Your Honour, past provisions in the Code which don't deal with claims here, to clause 49 under protecting official information. Members must not access, use or disclose any official information without proper authorisation or in circumstances that amount to a misuse of the information. Clause 65, under discrimination and harassment, the member must treat everyone with courtesy, fairness and respect. Page 10, under offensive language, clause 70, a member must not use language that under the circumstances another person may find crude, inappropriate, or offensive. Clause 71, members must not use any illegal drugs at any time. And finally, Your Honour, page 12, under reporting improper conduct or breaches of the Code of Conduct and Ethics. Clause 85, all members must report any suspected or actual breach of the Code of Conduct and Ethics or any suspected or actual improper conduct. Your Honour, that is the Code of Conduct that applies to all members, which informs members about potential breaches of discipline or failure to follow that or those clauses. And that is but one of potential risks under section 76 that a member might be exposed to in terms of a breach of discipline. Your Honour, one important aspect of the Part 4 scheme if I can take you to what Dr. Freckleton has referenced in his submissions, and that is the provision which deals with extensions of time under the Police Administration Act, which is section 162. Now, subsection 6, an action under part 4 in relation to a breach of discipline by a member shall be commenced within 6 months after the act or omission constituting the alleged breach of discipline was discovered, for such long a period as the Commissioner or local court judge allows under subsection 9. Subsection 7 deals with the period of time in which the application can be made. Subsection 9 deals with how the application is made and to whom. Subsection 10 deals with the matters that those who are determining whether or not to grant the extension must take into account whether or not to grant that extension. Now, Your Honour will be familiar with the decision of Justice Southwood in Holmes, as Your Honour appeared as counsel in that matter, and what Justice Southwood ultimately held, which is yet, is binding, has not yet been challenged since, was that an action for the purposes of Part 4 discipline is the charging of a member. The Section 79 notice is the precondition to all powers or functions exercised under Part 4. And Your Honour, in terms of Section 79, capital A, Justice Brownhill, in the decision of Turner via the Northern Territory of Australia, and that is citation 2021 NTSC 55, said at paragraph 149 of that judgment, Turner sought an order in the nature of mandamus compelling the board to require, pursuant to Section 79 capital A of the Act, those Scott and Jeremiah to attend the hearing and answer questions during cross-examination. Justice Brownhill says Section 79 capital A is not the source of the power to require a member to answer questions or provide information. It simply acknowledges that such power exists and addresses the common law right against self-incrimination. Now, Your Honour, in terms of assisting the court in response to Mr. Bowe's query, Constable Rolfe has submitted to a couple of section, what I would characterise as Section 79A interviews. However, as Justice Brown makes clear, that is not the source of the power. And they are interviews in relation to, as I recall it, the Ewan matter, the Bailey matter, the Madrill matter, and the Woods matter.
So just to be clear, is that 10, 12, 13 and 14 on the list? Thank you.
Now, Your Honour, that wording, date of discovery, is crucial in the context of misconduct or breach of discipline under Part 4. And Your Honour, can I hand to you and the other parties applications for extensions of time that were made into in relation to a number of matters. At the same time, I will also hand to you an affidavit of Commander Bacon in support of that, for those applications.
Are these being tendered?
I will tender those. I think at least the first two applications are on the brief, and the affidavit is as well. But for the purpose of this objection application, I think I should be on
The exhibit numbers.
Your Honour, I just wonder if they shouldn't be given MFI numbers in relation to the this application rather than separate exhibits in the hearing process.
I'm happy for them to be MFI on the application.
I think that's more appropriate with respect, Your Honour, and I note that the document that was referred to earlier, the Code of Conduct, is in the brief of evidence at 17-28, but again, it might be easier if that's MFI 1 and these two follow on the application.
Your Honour will see the first is an application for extension in relation to, in the second paragraph, the act or omission constituting alleged breach of discipline is the fatal force used that resulted in the death. And I won't say the name for obvious reasons. The date of discovery is 9 November, and noting the 6-month period to commence an action was 8th of May 2020, and the application was sought for an extension for 3 years and granted by the Chief Judge, Ms. Morris, Judge Morris. 3 years from the date of that approval, it takes to April next year, and that will be the same for all of the applications that follow. The second one is an application, or the act or omission, is the operational actions and decision making surrounding the pre and post deployment of the IRT, which resulted in the fatal force. It has the date of discovery, the period of expiration, again, is approved for 3 years. The next matter is the Malcolm Ryder matter, an application in relation to misrepresentation of evidence and professionalism in the prosecution, allegations surrounding perjury. It has the date of discovery. It also has the fact that a previous extension was granted, and this application was made and granted for a period of 3 years. However, I note in the matter of frankness to the court, that has since been, at least in correspondence to me, one interpretation is that extension granted by the Coronial Chief Judge was actually invalid because the previous one had been given. Now that might simply indicate ambiguity on the law, that might in fact be right, but nonetheless it doesn't affect the ultimate submission of the matter. The next one we see is in relation to the Albert Bailey, and yet again, complaint of excessive force. The application for extension is 3 years and granted by our Chief Judge. Same in relation to Antonio Wood, complaint of excessive force, applied for 3 years and granted by the Chief Judge. And finally, the application in relation to Wilton Drill, in relation to a complaint of excessive force, sought and applied for an extension of 3 years, which was granted by the Chief Judge. They are the applications that at least I am aware of in existence, and each of those, with the caveat I place on the Ryder matter, still have effect given the extension of time, whether or not they're valid. If I can take your honour through the affidavit of Commander Bacon, which was provided in support. Paragraph 3. The role of PSC, this is dated 6th of April 2020, is to review the circumstances of this incident and history of Constable Roth with a discipline lens. This is to ensure the Commissioner of Police has the ability to act on any identified discipline matters that may be discovered in this investigation, as well as consider any issues that need broader consideration surrounding policy and procedures within the organisation. Paragraph 7. In consultation with the Ombudsman Office, this period of time, referencing the 12-month extension that's available to the Commissioner above, only a judge can grant 3 years, this period of time is not considered sufficient given the circumstances surrounding Constable Roth and his outstanding matters. He then mentions there is also doubt, following the Holmes decision, that only one extension can be sought under 162, so the most appropriate application should be made to a local court judge, and so it was. Paragraph 8, and I start from the second sentence, talking about the complexities. Principally, this applies to obtaining the use of the evidence from Constable Roth himself, as well as any potential evidence that is uncovered or presented during the criminal trial process, which may or may not also be in the field. And I was aware from my submission at least that at least a couple of those direct interviews are taking place. Paragraph 9. There will also be a coronial investigation into the circumstances of this matter, where evidence obtained during this process may need to be considered in the discipline space. Your Honour, paragraphs 13 and 14, Commander Bacon references notes from the Joint Management Committee, and then lists under paragraph 14 all of the matters in which an extension is sought. I note at 14.4 that the matter which says statute expired in brackets relates to the Cleveland Walker matter, Again, as I wrote this submission, Your Honour, it is not fatal to the claim that is taken. If Your Honour turns to that annexure, which is briefing note 6, under the brief circumstances second paragraph, PSC are actively reviewing the criminal and coronial investigations with a discipline lens. These investigations will be leveraged upon to ultimately report to the Commissioner of Police on identified discipline matters and organisational issues. It then lists the fatal shooting, review of all members' actions leading up to and during the fatal shooting to determine what, if any, breaches of discipline have occurred. And you'll note in the box that deals with actions that require Part 4 action not yet commenced. Now, Part 4 action, if you want to recall from Southwood decision, Justice Southwood decision, is the charge of a member of the breach of discipline. Your Honour turns over to the Mount United matter, page 3 of the briefing note. It goes through a short history of that particular matter in relation to use of force, and it says over on page 4, PSC something to progress both matters from a discipline aspect. In the second box, discipline only relates to evidence presented in court or in responses to the ombudsman. Actions re arrest force have already been dispensed with. You might recall that was the decision that was made in 2018, which subsequently became a further complaint. Vice Judge Walker's handed down his decision, which was subsequently investigated. And then there's a discussion in the third box about a review and comparison, statutory declarations provided and evidence in court to determine if a serious breach of discipline has occurred. You then have the Cleveland Walker matter about it being expired. At page 5, this is the Madrill matter. No determination made re Part 4 action at this time. Further investigation required. That's in the third box. In relation to the Antonio Wood matter, on page 6, no determination made re Part 4 action at this time. Further investigation required. Under the recruitment information, which deals with the application process, consideration of Part 4 application, in relation to the Bailey matter. And Your Honour, this really forms a crux of what I would submit is the exposure to a potential penalty, and that is the basis on which I respectfully submit the claim can probably be taken. You will note in the third box, dealing with use of force during apprehension, this is the running across the council lawns. Body worn video identified and secured. Body worn video does not suggest excessive force when viewed in conjunction with the statement from Sergeant Evan Kelly. Issues identifying members due to wearing of unassigned body worn video cameras. No breaches of discipline detected. Likely to be finalised in the near future. Well, Your Honour now knows that in fact it was not or has not been finalised. It has resulted in the preliminary steps of Part 4, the preconditions of Part 4 as Justice Southwood refers to it, by the issuing of the Section 79 notice, consequent upon which charges can be laid. And so, Your Honour, whilst all the Territory Police might say this is finalised, or in terms of general capitalisation of disciplinary matters, if they are finalised, what does that mean? In terms of remedial advice, what does that mean? We've had a description about sitting down in a meeting and having an email. But if Your Honour turns to or reflects on the date of discovery, being the date upon which is the triggering event for the timeliness to apply, there are two ways in which matters which might be finalised or matters which might have resolved our remedial advice, some of those which still have an extension of time validly left on their face available to PSC in which to take Part 4 action. It can be the evidence from one's own mouth in the course of a coronial investigation, which might give rise to a new date of discovery for an act or omission or an impugned conduct. It could be, Your Honour, your findings in respect of certain activities, in respect of certain conduct undertaken by a member in the course of matters which you have indicated you will investigate. Either of those events, Your Honour, in my respect of submission, could be the trigger, we're talking about potential exposure to a penalty, could be the trigger for a date of discovery for any matter which might presently sit within the characterisation of out of time, or otherwise finalised, or otherwise dealt with by way of remedial advice. My respectful submission does not bring finality to those potential proceedings. I think, as Senior Counsel Mr Bolton indicated when Dr Freckling was going through an outcome rather outcome, to the effect of what disciplinary proceedings, or were there disciplinary proceedings. Disciplinary proceedings, Your Honour, are quite apart from remedial advice. Disciplinary proceedings are quite apart from sitting down with someone and sending someone an email reminding them to put their body worn video on. It is an action. That is the charging of a member. It is the precondition to the charging of a member, the service of a notice, which the person who serves the notice must form a requisite suspicion. All of these matters in Commander Bacon's affidavit are premised on the suspicion of a breach of discipline. And so, if a witness gets into the box, be it Constable Walker, be it any witness, who says something which is a fact that gives rise to a suspicion of a breach of discipline, and that is not whether there's a statute bar, there will also be Your Honour's findings, conclusion of your investigation, about whether you accept evidence or reject evidence of a particular witness, which could give rise to the date of discovery of a breach of discipline. And then that sets in train all of the motions under Part 4 which are taken into. So Your Honour, statutory construct and context is entirely relevant and important in the circumstances of this case. Your Honour, can I also emphasise, in relation to the Ryder matter, we tendered Exhibit 16, which was the email from Detective Superintendent Lauren Hill, and that was tendered on the 28th of October 2022. It was tendered on that date, but the email was received at 12:35 PM AEDT. Now, Your Honour, that was received and tendered in the middle of the evidence of Claudia Cantagnaro. Your Honour will see Exhibit 16. Hello, Constable Rob. This email is to provide formal advice to you, and I'll paraphrase it here for efficiency of time. It is determined there is no evidence to support the allegation of perjury associated to the comments made by Judge Borges following the hearing of the Malcolm Ryder. I've also reviewed the internal investigation. There is no evidence to support a breach of discipline, and the allegation is not substantiated. This email confirms internal investigation 044 is closed. Below that was an email sent to a number of other police officers involved in that incident, and it says this: hello, this email is to provide you with advice on a complaint against the police that was reopened and further examined due to the police shooting in Uindamu in 2019. Now, what possible connection that has, Your Honour, is beyond me, but nonetheless we now know that the Uindamu matter is still applicable to a extension of time in which Part 4 action can be taken. I have been told you may have been aware of this matter being re-examined. In June 2018, a complaint against police by Mr Malcolm Ryder was received. Sergeant Roach sought and received responses from each of you, which is consistent with the initial statements. The Section 92 report refers to the Ombudsman Act was signed and relevant parties notified of the outcome. The CAP was closed with findings, determined the police action was lawful and reasonable in relation to the use of force, and remedial advice was provided to Acting Senior Sergeant Roach via email and Superintendent Furness via email about the use of body-worn video. The hearing for Mr Ryder was held in Alice Springs. The charges were dismissed. Judge Borges handed down his decision, criticised the conduct of some attending members and considered the evidence untruthful. These comments were reported in the media. The publicly stated comments by Judge Borges were referred to PSC. I wish to confirm that the complaint against police is closed. So we have an instance, Your Honour, where it's closed or finalised. Remedial advice was given. Something happened subsequent to that, which is the decision of Judge Borges, and it's reopened. So, Your Honour, that only reinforces the submission when I say the significance of disciplinary proceedings and Part 4 action is date of discovery. It's not the date of the act or omission. It's the date when it becomes known to a police officer, disputedly whether it's a prescribed member or not, but nonetheless that's how it might be interpreted. It's when it is discovered. And so, Your Honour, one of the very significant issues in the context of the Malcolm Ryder matter, if I can turn to each of those cases to support or indicate the Ryder privilege is taken. In the affidavit of Assistant Commissioner Porter, dated September 2022, he says this in respect of the Malcolm Ryder matter. He prefaces it by explaining what Ms Campagnaro had said in her statutory declarations, and then says at paragraph 8, taking into account the statements of Ms Campagnaro and further examination of evidence gained in the complaint investigation, my view is that there is still insufficient evidence to determine whether the force applied to Mr Ryder was excessive in the circumstances, and he lists reasons as to why. Right, I just want to pause there for a moment and reflect on when he says insufficient evidence, which is littered, that those two words is littered among the table he attaches to that statement. He says this in his first affidavit, dated 13 July 2022, paragraph 17, page 13. As outlined in the police complaints agreement between the Commissioner of Police and the Ombudsman, the finding of insufficient evidence to sustain the allegation means, based on the material, there is some evidence to support the complaint, but it is insufficient to sustain the allegation. This may apply where there is some evidence to support the allegation, but the quality of the evidence is unreliable, or taking into account other evidence as a whole, is insufficient to sustain the allegation. Turning back to his second or third statement, I think it is, 2nd of September this year, he says this. When he talks about the insufficiency of the evidence, that is because the evidence of Ms paragraph 8. The evidence of Ms Campagnaro has been untested. We want to know she came before this court, she presented for examination and cross-examination, and she was tested. That evidence was tested. And that's going to be borne in mind in the context, Your Honour, where on the very same day we received notification from PSC, or Superintendent Hill, that all matters are closed. In a history of a matter which is open, closed, finalised, remedial advice given, but nonetheless she is now presenting her evidence. The veracity of the later claims by Ms Campagnaro contain insufficient details for any meaningful inquiry to be completed. 3. It is not known why Ms Campagnaro did not report any of the alleged disclosed conduct in her statements at the time. Well, I think she have evidence about why she did that, to the effect of that she was new, she was young, impressionable, etc. The information that she claims she was told indicates the Constable role to disclose these in the process of committing offences, including fabrications, false stat debt, including course of justice, not to mention serious breaches of discipline. The failure to report the alleged breaches at the time was a breach of discipline by her, if claims are to be believed. And as Your Honour knows from Mr Edwardson KC, that she had propositions put to her in cross-examination about those matters. Skipping forward to number 6, it is known that Constable Rolfe and Mr Ryder struggled on the lounge room floor, although the particulars of that interaction are unclear, with the version of events from both parties differing. Paragraph 7. If the claims by Ms Campagnaro were known at the time of the investigation, then further investigation would have been undertaken. I'm unable to hypothesise what additional evidence might have been adduced and what the outcome may be. may have been. Without further definitive information, there is insufficient evidence, bearing in mind what those two words mean, to determine whether the force applied to Mr. Ryder was excessive in the circumstances. And Your Honour, in respect of Ms. Campagnaro, and in your ruling number 2, commencing at paragraph 49, this is your ruling dealing with Constable Rolfe's objection to the evidence of Ms. Campagnaro. You set out some of the evidence she had given in her stat deck at that time. And at 49 you said, further passages from Ms. Campagnaro's evidence might be said to undermine Constable Rolfe's credibility concerning his use of force. You set out some examples. At paragraph 51, other aspects of Ms. Campagnaro's evidence might be said to suggest an over-preparedness on the part of Constable Rolfe to draw and or use a firearm in situations that may call for the use of force. Paragraph 53, other passages of the statement might be said to suggest concerning culture within the Alice Springs Police Station. And at paragraph 54, I do not express any view on whether the evidence of Ms. Campagnaro should be accepted as credible or reliable. There may well be significant issues with her credibility and or her reliability as a witness or interpretation of her evidence. However, at this stage, the evidence is rationally capable of acceptance. The interpretations are seemingly open, and the accounts are relevant to the inquiries I am undertaking. You finalise at paragraph 56 with that ruling. I note that the DPP has declined to charge Constable Rolfe with an offence arising out of these events, and that when he gives evidence, he may assume section 38 of the Crimes Act claim of privilege against self-incrimination before the raised. And at footnote 62, you state that Constable Rolfe is compelled to give evidence of his objection to the practical effect of decisions to confer a direct but not derivative use of immunity in criminal, civil and disciplinary proceedings. So, Your Honour, the effect of that is, whilst it might be categorised, that is, the Ryder matter is finalised in the sense or the views of the Northern Territory Police, bearing in mind what Your Honour's held, bearing in mind the history of that particular matter, it is completely in potential of exposure to a penalty should my client have evidence about those matters. And so, in my respect of submission, the Mountain Ryder matter is certainly well and truly right for the purposes of the claim.
How much further have you got?
Well, Your Honour, I need to deal with each of the matters which have otherwise been characterised as finalised. Much the same lines. I don't need to go chapter and verse. I can unpack it, but
No, I'm not asking you to truncate it. I'm not putting time pressure on you. I'm just trying to make a decision in relation to breaks. It's 12:30. Should we take the lunch break
I think it's probably appropriate to take the lunch break, Your Honour. We've been going since 10:30 and then resume at 1:30 if possible.
Yes. All right. We'll adjourn.
I didn't go inside.